Good afternoon, everyone, and good evening, Professor Park and our friends coming from North America. Welcome to the CUHK Faculty of Law, CCTL Corporate Law and Governance Seminar Series. My name is Chao Shi. I'm a professor at CUHK Law, and I chair this seminar series. Now, today we have the distinguished honor of having our speaker, Professor James Park. Now, Professor Park is a professor of law at UCLA School of Law. He's a leading expert on corporate law and securities regulation. His research examines the regulation of securities fraud and corporate governance in public companies. Professor Park has written more than 20 law review articles that have been published in some of the top-rated journals, such as California Law Review, Duke Law Journal, Journal of Empirical Legal Studies, Michigan Law Review, and UCLA Law Review. His book, entitled The Valuation Treadmill, How Securities Fraud Threatens the Integrity of Public Companies, was published by the Cambridge University Press last year, which also forms the focus of today's talk. Now, after graduating from Yale Law School, Professor Park clerked for federal judges in the Southern District of New York and the U.S. Court of Appeals for the Second Circuit. He practiced law in New York City at a law firm and then as Assistant Attorney General in the Investor Protection Bureau of the New York State Attorney General's office. Now, without further ado, Jim, I should pass on the baton to you. Now the floor is yours.
Thank you so much, Chao. Thank you so much for the invitation to present before your distinguished faculty. We've known each other for many years. Had the pleasure of meeting Chao at various in-person conferences in the United States, and I'm really thankful to have your friendship. And it's also wonderful to have colleagues across the world who are interested in corporate governance and securities fraud. One of the things that I think is distinctive about the United States is its emphasis on enforcement in developing regulatory norms. Many of the most significant cases brought in the US in the corporate arena involve allegations of securities fraud. My book tells the history of securities fraud and its regulation in the United States from about the 1960s until the present. It advances a novel thesis that so the securities frauds that ultimately led to the passage of Sarbanes-Oxley were caused, in a sense, by basic changes in the way that investors valued public companies that began around the 1960s and 1970s. And in advancing this thesis, I dissent to some extent from the prevailing view in the literature that securities fraud is mainly a problem of agency costs, disloyal agents who are trying to boost the company's stock price in order to boost their executive compensation. A bit of time in practice before becoming a law professor. I started work at a law firm about 20 years ago, right around the passage of the Sarbanes-Oxley Act of 2002. Enron had filed for bankruptcy in December of 2001, soon to be followed by WorldCom in 2002. And so my entire academic career has been shaped by the climate of that we saw towards the early 2000s in the United States, where there were significant major securities frauds that threatened the integrity of securities markets. I will now share my screen. I do have a PowerPoint presentation that I will share with you all. I hope you can all see that. Okay. So this is a history of securities fraud regulation. And one of the things I wanted to do is I wanted to write a book that focused not just on one or two major frauds. I wanted to discuss the iconic securities frauds over the decades, the frauds that I thought were the most important and representative of their times, so that we could compare and contrast these various frauds in order to gain deeper insights into how securities fraud has worked And my intuition has been that the problem of securities fraud has evolved over time. It does not remain static, and that really we see securities fraud becoming more of a regulatory concern as the public corporation becomes valued much more based upon its future performance. In some ways, we might understand this book as a defense of the Sarbanes-Oxley Act of 2002. Many of you know of the harsh criticisms that have been levied against this act, both in policy circles and by academics. The perception is that Sarbanes-Oxley has made it too expensive to be a public corporation in the United States because of its regulatory burdens. And there are often attempts to scale back some of the basic protections that are embodied by this law. And my view is that the act addresses a fundamental problem with public corporations, the pressure to meet projections and generate short-term financial results, which creates a systemic incentive for public corporations to commit securities fraud. And to me, the modern public corporation needs some measures like this to ensure that financial statements are accurate, and that this is a law that addresses a fundamentally structural problem that has evolved over the years. 40 or 50 years before the passage of Sarbanes-Oxley, the perception was that securities fraud was not a threat to large public corporations. It was seen mostly as an issue for small companies, companies that were not able to invest in internal controls, companies that were entrepreneurial, risk-taking, with inexperienced managers. This is an excerpt from a report commissioned by the Securities and Exchange Commission, an extensive study of securities markets during the 1960s. And the conclusion of the report is that the vast majority of SEC enforcement proceedings involve companies that are not listed on stock exchanges, and unlisted companies at the time were not subject to the periodic disclosure requirements of the Securities Exchange Act. So securities fraud was viewed as a small company problem. It was not seen as a risk for the large public corporations such as General Motors and IBM, which essentially dominated their markets after World War II. These corporations had market power. They were run by expert managers, and the perception was that they simply did not need to commit securities fraud. So what changes? What changes from 1964 to 2002? What makes securities fraud such a priority for the regulation of public companies? The seeds of the change that I think is driving securities fraud as a regulatory problem was also mentioned in the same 1963 report. And the report mentions the emergence of research analysts. We see beginning in around the 1950s, 1960s, the beginning of the institutionalization of stock markets. More institutional investors are becoming involved in these markets, and they want good information to assess the valuation of the stocks that they are investing in. In order to provide this information, research analysts become more prevalent and more common in stock markets. And at the core of the reports, as this particular SEC document notes, is a projection of earnings or revenue, predictions of how the company is going to perform. And this is a notable event. This is sort of the first time we're beginning to see projections emerging as an important method of valuation. Now, it was always understood that the value of a stock, to some extent, tracks the present value of its future cash flows, something that we all know now today, at least since the 1930s, with the publication of John Burr Williams' book, which argued that markets were focusing more on future dividend performance as to past performance in valuing stocks. But there was great skepticism as to whether or not we could accurately project corporate earnings. How can you predict the future? So what changes in the 1950s and 1960s, though, is that management becomes seen as more of a science. As organizations become larger, we see that there's a need to project within the firm. to develop internal projections of revenue and earnings. And Oliver Williamson's famous book on markets and hierarchies notes the emergence of internal capital markets where managers are allocating resources among different projects. And in order to assess which projects are more promising, you need projections of future performance. As the analysts become aware of these internal projections, they want them. They try to get them from managers, and oftentimes managers are disseminating this information over time to research analysts who are incorporating them into various present value models, discounted cash flow models, which we have a basic picture of such a model here. In order to project the future earnings over time, we have corporate projections that are combined with research analyst projections, and we have numbers that are metrics now that corporations to some extent must meet in order to maintain the perception that their earnings are going to grow in the future. So this change in valuation over time that happens beginning in the 1950s and 60s, in my view, is the foundation for the problem of securities fraud. When we begin having these metrics that can be gamed by corporate managers, there is greater incentive to misstate financial reports and other information in order to distort the perception of investors with respect to a company's future performance. So why do companies commit securities fraud? I think there are two basic stories that we often see with respect to these sorts of cases. One is you have a company that's trying to show that it has exceptional growth. It's a growth company that's outperforming its peers, and its future growth is expected to continue. The other situation is you have a company that was once dominant in some way, but its prospects are declining, and it's trying to hide that decline from investors in order to maintain its stock price. We begin seeing in the 1970s a couple of cases that illustrate these pressures. The first case happened maybe about 5 minutes from where I am sitting right now in Los Angeles. I live near Century City. If you're familiar with Century City, it's a second downtown area that is on the west side of LA near UCLA. There's an insurance company called Equity Funding that was located in Century City. It was listed on the New York Stock Exchange. And basically what it did was that it essentially fabricated insurance policies that it had claimed to have sold to people who did not exist in order to boost the company's sales. They had a separate office in the Beverly Hills area where lower level employees were creating fake files. So when the auditors came to verify these sales, they had something to show them. To make matters even worse, they reinsured these policies. They ceded the risk to reinsurers, which obligated them to pass on future premiums, which was a problem because those premiums were not being paid since these insurance policies were fake. So a very significant, massive fraud. Why did they do this? The report of the bankruptcy examiner, I think, is telling. The bankruptcy trustee basically said this is a securities fraud. The motivation for these fabrications was to show that the company's earnings were increasing over time. And this was meant to fool markets into thinking that Equity Funding's prospects were much greater than they actually were. The CEO's staff basically begged him to stop doing this. We're all going to go to jail. But as the report mentions, he flatly rejected the proposal to stop this scheme because he could not report flat earnings. And so one of the first major securities frauds that we see that indicates that around this time we're beginning to see that the pressure of valuation is affecting incentives to misreport information to investors. Equity funding, if you're familiar with insider trading law, this is the fraud that generated the Dirks case on tipping liability. Part of the reason that the fraud came to light was that somebody from within Equity Funding tipped off a research analyst about the fraud, and he told some of his clients, and there's a question as to whether that was insider trading or not, and the court developed its famous a test for insider trading based on tipping information. An example where a corporation misstated its financial statements in order to prevent the perception that it was in decline was Penn Central, the nation's largest railroad, which had been formed by a merger just a few years ago, suddenly filed for bankruptcy. The merger was motivated in part because of increasing competition from national highways, the interstate highway, from cheaper air travel, which made the demand for rail travel less strong. And basically what Penn Central did was that they sold assets that had been acquired in better times in order to increase their revenue, to offset the decline in their operating revenue, in order to create the perception that they were turning around the company. Now, selling assets in order to generate revenue is not a misstatement of any kind. Managers have discretion to sell assets to generate revenue, but there were a handful of transactions that were problematic from an accounting perspective. One of them involved a Six Flags amusement park that was located, I believe, in Texas. Penn Central basically sold one of these parks to a partnership of investors for around $29 million. They had a side agreement, though, that basically where Penn Central agreed to retain the risk of loss on the asset. And the problem here is that if you're retaining the risk of loss, you can't count this as a sale, right? A sale requires you to transfer the risk of loss. And we saw transactions like this decades later in the Enron case, right? Part of the reason Enron gets in trouble is it's, selling assets to special purpose vehicles without effectively transferring the risk of loss. And so it was problematic to count these transactions as sales and include them in revenue. So the defense of the auditors of Penn Central was not that the accounting for the sale was permissible under generally accepted accounting principles. Their argument was that it was not a material misstatement. They claimed that a $29 million transaction like this was so small that it would not materially affect investor perceptions of Penn Central's financial condition. Abraham Brilloff, who was a famous accounting professor, taught at Baruch University in New York City for many years, wrote a telling response in Barron's. And in his article, he points to the fact that Penn Central needed this $29 million in order to show a small profit in a period when it had predicted a favorable showing. Without this particular transaction, it would have had to report a loss. So we see meeting a projection was the motivation for this particular misstatement. And so we're beginning to see some of the influence of these projections that are becoming more important as research analysts become more influential in stock markets in the 1970s. And this changes our conception of materiality from a securities law perspective, where a relatively small misstatement can still be material or important to investors if it allows the company to meet certain short-term projections. During the 1980s, we saw a surge of securities litigation against technology companies. The 1980s was a time when computer companies were booming, and investors were often willing to pay significant amounts for a technology company stock based upon the prospect of a successful product that would generate revenue in the future. But to the extent that there were problems with the product, the stock price could quickly adjust as investors took into account the risk that the product would be a failure. So a recent example, or an important example of this sort of litigation involved Apple Computer before it became the world's most valuable corporation. It was a newly public company. that was trying to build upon the success of the Apple II home computer. Some of you may remember that particular device. It helped propel the company from a company in a garage to a billion-dollar public corporation in just a few years. But Apple needed to show it was not just a one-hit wonder, that it could build products that continued to generate revenue. And so what it was trying to do was develop a computer for office use. And they called this computer the Lisa. And one of the attractive features of the Lisa was that it had a disk drive, a high-performance disk drive that was called the Twiggy. This was the day before large hard drives and cloud computing. You needed a fast disk drive to load up your programs. And so this is an excerpt from the Ninth Circuit opinion that decided that the case could proceed to trial. And it notes a number of statements made by Apple. And one way of reading these statements is that they essentially represented that the Twiggy was complete, that Apple knew that the product worked, that it had been subject to extensive testing, when in fact, the product was not finished. And the Twiggy turned out to be defective and had to be discontinued. Apple's stock price fell by about 20% once this was revealed to the stock market. And so the question at the end of the day is, did Apple know that the Twiggy would not work? At trial, the plaintiffs presented evidence that they found through discovery, internal memos written by engineers indicating that they thought that there were too many problems with the Twiggy's reliability that would lead us to delay the introduction of Lisa by many months. These were memos that were being circulated at the time the more optimistic statements were made to the public. Steve Jobs, who had been kicked off the Twiggy project in order to work on something called the Macintosh, said that he had virtually no confidence in the division responsible for the Twiggy. So the plaintiff's argument was simply that you made a material misrepresentation about the product and its prospect for success. The defendant's argument, their response was that this is simply how product development works. There's always a fire drill at the end where we're trying to get the product to work. And if you make us liable for securities fraud in these circumstances, you're going to squelch entrepreneurship. You're going to penalize risk-taking. And this is not fair. It's not a fair liability standard. At trial, the jury agreed with the plaintiffs and awarded them $100 million. This sends shockwaves through Silicon Valley. The verdict and other verdicts like this influenced the US Congress to pass the Private Securities Litigation Reform Act of 1995, which provides safe harbors for various forward-looking information and enacts various procedural barriers to private securities claims. So these types of product misstatement cases can be very controversial. They often hinge upon interpreting various statements that are made to the public and assessing the company's internal knowledge. You might think these are somewhat frivolous types of lawsuits. There's some argument that these types of product claims were simply strike suits against technology companies whose stock prices inevitably fluctuate. But the basic theory is still one that is the basis for liability. A very recent example from a few months ago involved Trevor Milton, the founder of a company called Nikola, which is trying to develop clean energy semi-trucks that run on hydrogen. And he was convicted criminally of securities fraud in the Southern District of New York. Many of the statements that were the basis for the conviction were similar in nature to the ones that we saw in the Apple case. Misstating the availability of proprietary technology that the company had not actually developed. One of the more notorious misstatements that you may know about that Nikola made is that they were trying to show that one of the prototypes of the trucks was functional and it could be driven. It was not yet functional. And so what they did is they took the semi-truck to the top of a tall hill and they pushed it down the hill, and they basically filmed it basically rolling down the hill and represented that the truck was being driven based upon this hydrogen technology. Another example of a misstatement like this that resulted in criminal securities fraud liability, of course, was the conviction of Elizabeth Holmes about a year ago for misstating the condition of the blood testing machines developed by Theranos. She claimed that they had machines that could run multiple tests on a single drop of blood, when in fact they did not. So these types of claims are controversial, but they can result in liability, sometimes even criminal liability for violations of securities fraud statutes. By the 1990s, projections become even more important, and it becomes important not only to meet projections on an annual basis, but on a quarterly basis. At some point in the late 80s, early 90s, projections become much more disseminated among market participants and become a much more important test of companies' valuation. And so we see a number of cases of accounting fraud by public companies in order to meet projections. So a very significant example of such a case involves Xerox, the iconic inventor of the copy machine. Xerox, towards the late 1990s, basically moved up billions of dollars of revenue in violation of GAAP with respect to its sales of copiers and other services relating to those copy machines. Why did they do this? Well, the effect of the GAAP violation was to allow Xerox to meet its projections in 11 of 12 quarters. This was the first time the SEC imposed a substantial corporate penalty, a penalty against a corporation for securities fraud. They penalized Xerox $10 million in the early 2000s. Now, simply violating GAAP, as you may know, is not sufficient to violate Rule 10b-5, one of the more severe securities fraud rules that is out there, because corporate managers are not necessarily experts in accounting. GAAP is very technical, and it's often possible to make mistakes in the application of accounting principles. So in order to show scienter, fraudulent intent, which is an essential element of Rule 10b-5, you need to have a broader story, a story of why the misstatements were made. Why did Xerox violate GAAP? What justified a $10 million penalty? And I think the answer to some extent is hinted at in this Wall Street Journal article, which is published around the time that the GAAP violations were happening. The front page story in the Wall Street Journal, where the CEO is basically telling the story that Xerox is beating back competition from foreign copy machine makers, as well as the digital revolution, right? With the rise of the internet, we have less of a need to make copies. I can just email documents to my coworkers. I don't have to copy them and distribute them physically. But he's telling a broader story to the market that Xerox's prospects are still strong. We're beating our competition. And what does he point to as evidence that the company is continuing to perform? He points to double-digit US revenue growth. Without the GAAP violations, though, he would have had to report flat earnings. He would not have been able to tell this story. And this is the bigger, broader story, I think, that the SEC pointed to in determining that there was fraudulent intent in this particular case. Somebody asked about the auditors. The auditors are another story. They were also penalized by the SEC for failing to stop this particular fraud. Some of Xerox's auditors did raise issues. The one that did was fired. That was part of the complaint. You know, they had two sets of books in a sense, and the auditors knew of these two sets of books, one that included the GAAP violations, one that did not. And so, people often ask me, well, isn't the problem the gatekeepers, the auditors here? And that's the famous argument that Professor Coffey made many years ago, and certainly the gatekeepers should have done a better job. But to me, who is fundamentally at fault when you have an accounting fraud? To me, it's the managers that are perpetuating the fraud, the corporation that is, because they are pushing the auditors to accept aggressive accounting or questionable accounting. And sometimes auditors are fairly willing participants in securities fraud. Sometimes they're also fooled as well. And so my story does emphasize something a little bit different than the more prevailing conception that focuses on auditors and executive compensation. To me, the valuation pressure, in my view, is a more fundamental cause, more fundamental reason why public corporations begin to systematically commit accounting fraud during this particular period. Okay. So there were dozens of cases like this, dozens of cases where the SEC's theory was that an accounting misstatement was made in order to allow a public company to meet its projections. I'm often asked by students and others about criminal securities fraud liability, right? When is a securities fraud criminal? And it's a very difficult question to answer. The line between civil and criminal is a fuzzy one. Enron is an interesting example of how criminal cases were built with respect to these various accounting frauds. And I think there are a number of points that can be made by looking at the Enron fraud that may support my thesis that projections were driving much of the fraud that we saw in the late 1990s and early 2000s. As many of you know, high-level executive Jeff Skilling, Kenneth Lay, they were convicted of securities fraud in the Enron case. And as many of you know, Enron was a massive accounting fraud, billions of dollars of liabilities shifted off the company's books in an improper way. The interesting thing, though, about the criminal case is that it really didn't focus on the larger misstatements that were made by Enron. The prosecutors honed in on what were fairly small misstatements given the $70 billion market capitalization of Enron. You have smaller transactions of $7 million, $12 million that were part of the prosecution's case. Why did they focus on these small misstatements? If you read the Fifth Circuit's opinion affirming the conviction of Skilling, the opinion points to projections. This is a famous transaction involving the sale of Nigerian barges located in Nigeria that Enron sold to a special purpose vehicle. Why did they do this? Part of the reason was to meet an earnings target at the end of the quarter. And you see similar types of allegations for these sorts of misstatements. Even though it's relatively small, it's material because it allows a company to meet a projection. This is the theory that we saw all the way back in the Penn Central case. By the early 2000s, this is the basis for a criminal conviction. What was improper about this particular transaction? Well, part of the reason Enron should not have counted this as a sale that generated revenue was that Skilling personally told Andy Fastow, Enron CFO, who was running the special purpose vehicles, that he would make sure that LGM, the special purpose vehicle, would not lose money on the transaction. And as he saw back in Penn Central, this is not a sale, right? He's guaranteeing LGM against a loss if you read the statement in a certain way. And so this was not a proper sale. And Skilling was personally involved. He was personally involved in this particular transaction. It could be traced to him. And so we have a basis for individual criminal liability, knowledge of improper accounting meant to fool investors by meeting a projection. Now, Skilling's response and defense, I'm sure, is that Fastow is lying. He made this up. There was no agreement. But this is what happens in criminal cases every day in the US. We rely upon cooperating witnesses who have an incentive to point the finger at others in order to get a more lenient sentence. And this is simply an accepted part of our system, and prosecutors have to find corroborating evidence in order to assure themselves that there is not a lie made by this cooperating witness. This happens all the time. The FTX case, that the criminal case against Sam Bankman-Fried, I expect, is going to hinge upon similar types of cooperating witness testimony. The reason why the federal prosecutors in that case were able to bring cases so quickly is that high-level managers at FTX who worked with Sam Bankman-Fried, they came in, they're cooperating, and they certainly are going to provide information, testimony that he was personally involved in the diversion of customer accounts. And so this is what criminal cases hinge upon. They're very difficult to make, they're very difficult to develop, but they are developed at times. And I think that the fact that we had dozens of other cases like this before it that proceeded civilly might have provided the foundation for criminal cases that were later brought against executives at Enron and WorldCom. The response to these frauds, as you know, was the Sarbanes-Oxley Act of 2002. One of the major things it requires public companies to do is to assess their internal controls. An outside auditor has to attest to that particular assessment. The PCAOB, the Public Company Accounting Oversight Board, which was created by Sarbanes-Oxley, provided some guidance to auditors in reviewing internal controls. And it's telling that what the PCAOB focuses on is meeting projections, right? Significant unusual transactions, particularly those that result in late or unusual journal entries, adjustments made in the period end financial process, significant management estimates. And this is telling. This shows over time the influence of projections as a structural feature of securities markets that create a risk of securities fraud for virtually all public corporations. And so in assessing internal controls, part of the reason we have internal controls is to make sure that corporate managers are not gaming this particular system. And so we go from a report in the 1960s, which concludes that securities fraud is a small company problem, to 2002, where it's recognized that every public corporation needs to have internal controls that are directed at manipulation of projections and earnings management. So fast forward to the present. You know, over the last decade or so, we have seen fewer cases alleging GAAP violations in cases filed by private plaintiffs and the Securities Exchange Commission. They do come up from time to time, but we haven't seen another Enron or WorldCom. What's happening, there's a belief by some that that companies are still managing earnings, but they're shifting to real earnings management. And the SEC has made it a point to bring a number of cases that highlight real earnings management practices, which essentially manage earnings without violating accounting rules. General Electric was sued by the SEC a few years ago and settled in enforcement action for $200 million. As you know, GE, in 2017 revealed massive losses in its energy and healthcare businesses. Stock price fell by 80%, and the company's not really recovered since then. More market value was lost in GE stock than Enron and WorldCom combined. So what did General Electric do, and what made it a violation of securities law? One of the things it did was it basically sold receivables. It sold receivables to generate cash in its various businesses. And there's no GAAP violation here, right? Managers have some discretion to sell future cash flows in order to generate cash now. And as many of you know, it's been an open secret, or it was an open secret for many years, that General Electric manages its earnings. It's a big conglomerate. It sells assets when it needs to generate revenue to meet projections. And this is a front page story in the Wall Street Journal from the 1990s, where there's sort of a story about how GE basically dampens fluctuations in its earnings, and that's why GE stock was attractive for so long for so many investors. It had very consistent results, very smooth earnings, and that predictability, of course, is going to be reflected in the company's stock price. And so one might ask or question, well, if GE has been managing earnings all this time, what was different? Was there something different about what it did? And I think there are a couple of arguments that the SEC made about the sale of receivables as to why it was misleading to investors. The first goes back to our theme of projections, right? Part of the reason they were generating this additional cash was to meet investor and analyst concerns, to meet cash flow projections. So they knew that the markets were focusing on these numbers. And so they were managing for a particular reason. They had a motivation to deceive investors about the condition of the company's cash flow. A second important point is that they knew, right? They knew that this was not sustainable. They knew that the power business was declining. They had internal documents indicating that it was not sustainable. And here we have sort of a similar theory as what we saw in the Apple case, where there's a divergence between what the company's portraying to investors and their internal knowledge of the reality that they are that they recognize within the company is that we just can't keep this up. We're creating a misleading appearance because we're sacrificing future cash revenue and we're not going to recover. We can't keep this up. And to the extent that they're creating the appearance that the company's cash flow is still strong, that is materially misleading to investors. So a very significant sort of case that I think the SEC brought in order to send a message to public corporations. Another recent example from about a year or two ago involved Under Armour, the sportswear apparel company. In order to meet analyst revenue estimates, they pulled forward various orders for its products. So the baseball team might need new uniforms in the spring. Under Armour may call them up and say, will you take them in the fall in order to allow us to generate more revenue? An interesting point made by the SEC in its complaint is in this footnote. They specifically noted that the order makes no findings that the revenue was recognized in a way that violated generally accepted accounting principles. And I think this highlights the SEC's view on real earnings management. You don't have to violate GAAP in order to violate securities laws. You can mislead investors by using real earnings management. In certain circumstances, we're going to say that this is a type of securities fraud. The other interesting point from this decision is that the reason they did this is because they were trying to meet projections of 20% revenue growth. It was not enough for them to grow the revenue by 10 or 15%. They had to show exceptional revenue growth, and they used misleading ways of trying to portray that to investors. So another case that I think is sort of a part of a new SEC strategy to shift some resources into penalizing real earnings management and clarifying that you don't have to violate generally accepted accounting principles to mislead investors by meeting projections. Okay, so I thought I would conclude with just a brief note about the future of securities fraud regulation. As you know, ESG disclosure has become a more important part of the regulatory landscape. And we're beginning to see the SEC bringing cases alleging that public companies have misled investors with respect to ESG risks in their disclosures. And in a sense, this is an argument that the company is misleading the market about future performance. You're minimizing risks so that investors will not take them into account in projecting future cash flows. And so this is another evolution, if you will, of securities fraud and securities fraud theories. And that's one of the themes of my book, is that securities fraud has not remained constant over time. It has changed as regulatory priorities have changed, as the public corporation has evolved and changed. This is a case brought against Vale, which is a Brazilian mining company with ADRs listed on the New York Stock Exchange. One of its dams collapsed in Brazil, caused significant environmental damage. The stock price fell, and they're not only penalized by Brazilian authorities, they're also sued for securities fraud by the SEC. There's been a trend towards these disaster cases or event litigation, as some have described it as. I describe it as ESG securities fraud. And there's a running joke by Matt Levine, the Bloomberg columnist, who says, well, everything's now securities fraud. Every time something bad happens to a company, they get sued. There's allegations of securities fraud. And I think the criticism is maybe halfway right. It was not the case, though, in Vale that just something bad happened. Vale had internal studies and estimates indicating that there was a high risk that the dam would collapse. So they had knowledge. They knew about the possibility of a significant environmental disaster, just as Apple arguably knew about a significant risk that the Twiggy might fail. And so in some ways, these ESG risk cases are not all that different from the product failure cases we saw in the 1980s. So they're controversial, but I think that in some cases there is a sound footing to argue there is securities fraud when there's a significant divergence between the manager's internal knowledge of risk and what they're portraying to investors. And what Vale did in its various disclosures was, in sustainability disclosures, it represented that its dams were safe, while knowing they had internal estimates of a high risk of collapse. That's a misstatement. That's a misrepresentation. As there's more pressure for companies to voluntarily issue ESG disclosures, I expect we'll see more ESG securities fraud cases because there are more opportunities for there to be material misrepresentations with respect to significant ESG risks. So I have an article I'm working on that sort of fleshes this out a little bit more. And to me, the key consideration in these sorts of cases is, whether this is a risk that can be calculated in a reasonable manner. Is it a Knightian risk versus a Knightian uncertainty, where probabilities cannot be generated? To the extent that it is simply an uncertainty that no one could really predict, I think liability is probably improper in these sorts of cases, but the extent that the risks are actually being calculated and can be calculated in a meaningful way, that we can see viable securities fraud cases in these situations. So that's the end of my presentation. Thank you so much for listening. I hope that this is the sort of book that would be a very nice introduction for those interested in securities fraud regulation in the United States, to get a historical perspective. And in some ways, it's also a history of the public corporation in the United States, how it has changed over time. And so I hope that if you're interested, you have a chance to take a look, and recommend to any students who are interested in the US system better. Thank you very much. And I'm happy to take questions to the extent that that you have any.
Well, thank you so much, Jim, for such a illuminating and also very thought-provoking talk. I think this is something that everyone should perhaps pay greater attention to. And you have guided us through this decades-long saga of securities fraud in the US. That is most fascinating. And I think everyone should really, who takes any interest in securities markets, should perhaps have your book on the bookshelves. It's a fascinating piece of work. We do get I have a couple of questions, but we do get a couple of questions from my colleague, Professor James Zheng, who is also a Yale Law School alumnus. So if you don't mind, I can perhaps pass on James' question to you first, and maybe have a couple of other quick follow-up questions as well. Now, so this is Professor Zheng's first question, which is, just read out, quote unquote, what about securities fraud committed during the IPO stage to raise funds? Is it common in the US?
It's a great question. You know, that was the initial concern of the securities laws. And that's kind of an interesting story in of itself, is that the securities laws are initially passed because of the perception that companies selling securities in initial public offerings are perhaps less certain in their prospects and have incentives to create fraud in order to sell securities. And so, you know, the sort of shift to securities fraud cases often brought against more established companies is something that happens later. But I think throughout the history of securities regulation and initial public offerings, that has been a constant, that there are allegations of fraud brought against companies in the IPO setting, the IPO context. It's difficult, though, to kind of measure whether the problem has changed over time. And you know, I think there's something inherently risky about investing in companies in such an uncertain stage. And as a result, we have Section 11 of the Securities Act of 1933, which is a type of securities fraud statute, but it's one that is that does not have a requirement of scienter. And so there's a very harsh form of liability, and much easier to win a case against a company doing an IPO than a company that you know, has allegedly inflated the price of its stock that is trading in secondary markets. And so these Section 11 cases are brought very frequently, but it's a little bit more difficult to sort of tell whether we have a fraud in those cases, because you don't have to actually prove fraudulent intent. You only have to prove a material misrepresentation in the registration statement. And so if you're asking, are there often material misrepresentations in registration statements, I would say probably yes, at least from the plaintiff's perspective. And you see very significant settlements involving Snap, for example, and other companies that have done IPOs. But it's very difficult to sort of, you know, determine, is it fraud in the sense that there's some fraudulent intent? Now, you may say that there's always a motivation to commit fraud in the IPO context, because you're receiving funds for the sale of securities. So I would say that I think that there is fraud in IPOs. I'm not sure that the problem has changed all that much over time, although you could say that as technology companies become more prominent and investors are willing to pay high prices for their shares, there may be a greater risk of misstatements and fraudulent IPOs, but it's something that is not part of the story I'm telling in this particular book.
Well, that sounds like a topic for another book.
That's right.
All right. The second question from Professor James Zheng, which is, are there regulatory rules, I suppose, in the US, such as rules that delist company committing securities fraud?
It would be very, you know, I think that is a penalty I've not really seen. You know, I think that you often have companies that have committed some sort of fraud, and they continue even after they're being sanctioned. And so I'm not familiar of a rule that would permit such a strong sanction for fraudulent conduct. I think we'll see, you know, the highest sorts of sanctions are the criminal sorts of sanctions that we saw in the Enron and WorldCom setting. But, you know, you often see companies that deceive investors in some way, that they continue And Xerox, for example, continued as a public company for many years. And it's an interesting question as to whether such a harsh, could there be situations where such a harsh remedy could be imposed? Maybe. But at the same time, I think there'd be a reluctance for U.S. regulators to take such a step.
Professor Park, maybe this is Jameson. I was hoping that perhaps I could ask a follow-up question just directly. So in mainland China, where I study securities law, there's a kind of a phenomenon that a lot of the listed companies commit securities fraud because they were facing pressure to be delisted. So the idea is that the securities regulator require them to make a profits for a few years. If they continue to suffer losses, then they might be delisted. Then so they're under the pressure to commit some kind of securities fraud to make it look like they have met the requirements, so that they can remain listed. I was just wondering whether there's something similar in the US. Yeah,
that's really fascinating. That is really fascinating, and stock exchanges do have various rules that would require delisting in certain circumstances, and you could imagine smaller companies, from time to time, and I have seen cases like that where they are facing the threat of delisting and they may misstate financial statements, and part of the motivation may be to avoid that situation. And I think though that that I think that certainly could be a motivation, and that would typically affect maybe more smaller companies, mid-sized companies that have fallen on hard times, and I think that certainly is something that I recall seeing cases that are like that.
Fantastic, that's fantastic. James, all right. Thank you, James, my professor, my colleague, Professor. Maybe one final question, Jim. I know it's getting a bit late in LA, so we don't want to hold you for too long. When I listened very carefully to what you said, I was having this question in mind, which is what might be the implications of your research to the current debate on shareholderism versus stakeholderism. So you're looking at projection or quarterly capitalism, which are pretty much driven by this how should I call it shareholder orientalism.
Yeah.
So are you suggesting that a move towards stakeholderism might help, or is it not relevant at all? So maybe this is
I think it is relevant
reflection.
I think it is very relevant, Chao, and I have an article called "From Managers to Markets," which makes a bit of a broader argument that changes in valuation, in a sense, have sort of resulted in sort of the more shareholder wealth maximization mentality in the United States, and the question then is, if you want to move away from that, how can you do that? I think that you need a more emphasis on long-term valuation, and that may require a broader consideration of stakeholder interests. And I think there is an attempt, ESG disclosure to some extent is an attempt to sort of move away from a system that relies so much on short-term projections. And I am I don't take a clear position though as to whether I think stakeholderism is a good thing. I think that it's a complicated issue. There are reasons why we want to assess short-term performance, but I do have some proposals at the end of the book, which offer a few suggestions for perhaps reducing some of the pressure of short-term, meeting short-term projections, increasing disclosure about projections and the basis for the projections so that they're more conservative, so that investors have a better understanding of how those projections are generated. That might reduce some of the pressure of projections. And if you have less pressure on public companies, they may be able to do more to consider broader stakeholder interests. And that's certainly something that I think could have some benefits, but it is, it's a complicated set of questions, and one that I will keep thinking about over the years.
Thank you so much. That's something I think probably is on everybody's mind at the moment, but you have offered a very, very important perspective.